Welcome. My guest is Wayne Outten. He is the founding and managing partner of Outten Golden, headquartered in New York City. His practice focuses on representing individuals in all areas of employment law. Wayne, welcome.
My pleasure. I'm glad to be here.
So let's talk about your background. You started out at NYU, but employment law wasn't your focus. How did you get interested in that area of the law?
Well, while I was at NYU, I became a protege of Norman Dorsey, who was then the president of the ACLU. And to make a long story short, he asked me to write a book on the rights of somebody, and I ended up writing a book on the rights of employees. The book finally came out about 1984.
Employment law, Wayne, covers a broad area. Can you talk about that?
Well, I was lucky enough to be in the right place at the right time because the employment law field, as we now know it, was just beginning to take shape in the late 60s and early 70s. The Civil Rights Act of 1964 was passed, of course, in 64. That was the first broad-based statute that provided rights for employees. It provided for rights against discrimination based on race and sex and national origin, religion, and things like that. And it was really a civil rights statute at the time because it applies not just to employment but also to housing and voting and education. But it became kind of the foundation stone for the field that we now know as employment law. And over the ensuing years, there were other statutes passed. The Age Discrimination Employment Act, the Americans with Disabilities Act, the ERISA, Employee Retirement Income Security Act, the Family and Medical Leave Act. All of these were federal statutes that were passed in the 70s, 80s, and 90s that provided for protection for employees. And at the same time, in the state courts, there were cases that were beginning to chip away at the employment at will doctrine that has been the foundation stone of employment law for 100 years. And courts started making exceptions to provide rights for employees if they were retaliated against or discriminated against for engaging in certain kinds of protected conduct. And so I was lucky enough to be in the right place at the right time while the law in this area was unfolding.
Wayne, you have many areas of practice within employment law.
Well, our firm has three basic categories of matters that we handle. One is transactional, two is class and collective actions, and three is individual claims. Our transactional practice involves representing employees, typically executives and professionals, but not exclusively, who are joining companies, and we help them with their employment contracts or maybe partnership agreements, or they're leaving companies, and we help them with their separation agreements. We help people with consulting agreements, and all the issues that arise with the coming and going from one job to another. And of course, sometimes there are issues that arise during the employment, issues relating to compensation and benefits. And so we're involved in representing people with those kinds of transactional type issues. We have a major part of our firm that's class and collective actions under the wage and hour laws, for example, relating to overtime and minimum wage claims, and class actions relating to discrimination based on gender, discrimination based on race, things like that. That represents more than half of our firm's overall practice. And then the third category is individual matters, individual claims, where we have clients come to us who have been fired or who have been harassed or who have been discriminated against, perhaps in their pay or in promotions, and we advise them, we help them negotiate, we negotiate on their behalf, and when necessary we bring EEOC charges and we bring lawsuits. And sometimes there are arbitrations as well to enforce their rights. And part of that individual practice also is employment contract claims. If an employee has a claim arising under an employment contract or a benefit plan or a compensation plan at their employer, oftentimes these end up in arbitration, and we handle those kind of cases routinely. And we've had some very successful results with some of those kinds of cases.
So Wayne, you personally have had some successful high-profile cases. Can you talk about the Morgan Stanley case?
Well, this was a case that got a lot of attention at the time. The case was settled in 2004. We represented Allison Shefflin, who was a woman in the institutional equity division of the company at Morgan Stanley. And long story short, she complained that she had not been properly paid and promoted compared to her male colleagues. We filed a charge with the EOC. The EOC decided that the claim had merit and decided to bring a pattern and practice case, which is something that's within the special jurisdiction of the EOC. And we ended up bringing a case together. The EOC brought its pattern and practice discrimination case on behalf of other women in the Institutional Equity Division, and we brought our case on behalf of Allison Shefflin. The case was litigated jointly, and we were actually on the eve of trial in July of 2004 when that case was settled. The basic issue in the case was whether or not these women in the Institutional Equity Division were being promoted and paid in a manner consistent with their male counterparts. The total amount of the settlement was over $50 million, of which $40 million went into a pool that was allocated among the women in the class, and my client, Allison Shefflin, was awarded $12 million of that amount.
And can you also talk about the arbitration case with Deutsche Bank?
Well, until just very recently, it was the biggest award that we've gotten in an arbitration case. It was about $19 million on behalf of two individuals under a compensation plan. We went to trial and succeeded in winning on the merits and getting interest and attorney's fees in the aggregate amount of about $19 million. Just last week, we got an award in a case. I can't identify the company involved for confidentiality reasons, but we represent a group of about 20 people under a compensation plan, a profit participation plan it was called, and we had a trial in November for 2 weeks, and we just recovered an award that will be in excess of $70 million for this group of people.
Wayne, you also have specifically some very interesting, fairly new practice groups in employment law. Can you talk about those?
Sure. Several years ago, we decided to organize our firm into practice groups. Just the law generally is getting more and more specialized, and within the field of employment law, which is our area of focus, there are many, many subspecialties. And so we created about 10 practice groups so that a group of lawyers within our firm will focus primarily, if not exclusively, on handling certain kinds of matters. That way we can stay at the cutting edge of the developments in those areas. One of our practice groups, for example, we call executives and professionals, and that's focused on representing, as the name implies, executives and professionals, typically in transactional matters like employment agreements and separation agreements and everything in between. We also have some pretty unusual and interesting practice groups. One is the LGBT, lesbian, gay, bisexual, and transgender practice group. We're one of the few firms, if not the only firm in the country, that has a practice group focused on representing people in the LGBT community. There are really two parts to that, actually. One is the issues of special import to people in the LGBT community, issues of arising under sexual orientation statutes and related issues, but also just representing people in that community about their employment issues generally. We have an LGBT-friendly firm, and the lawyers in our firm and the staff in our firm are quite understanding and sensitive to people in the LGBT communities, and so we hope that they will come to us whenever they have any kind of employment issue, not just LGBT-oriented types of issues. We also have a practice group that we recently started relating to the special areas of e-discovery, that is electronic discovery in all kinds of civil litigation. And it's an increasingly specialized, highly technical area of law that many firms, particularly employee-side law firms, don't have the resources to handle. And so we are developing in-house expertise so that we can do expert e-discovery work, A, for our own cases, and B, to be a resource to other firms that don't have the resources to handle e-discovery issues at a really sophisticated level. We also have practice groups relating to issues of sexual harassment, disability law, family responsibilities discrimination, discrimination and retaliation generally, whistleblower rights, and of course class and collective actions.
Wayne, how many lawyers and how many offices do you have?
Well, our main office is in New York City. We have about 32 or 33 lawyers right now who are regular staff lawyers, partners of counsel and associates. In addition to the main office, we have a satellite office in Westport, Connecticut. We have an office in Chicago, and we have a satellite office in Denver, Colorado. But the vast majority of the lawyers and the staff are in New York City. In addition to the lawyers, we have a large pool of paralegals who provide great service for us, particularly on our class and collective actions. I'd say we have about 20 or 25 paralegals at any one point in time.
Well, finally, Wayne, do you still consider yourself a boutique law firm?
Well, we are a boutique firm in as much as we have a very narrow focus for our practice. We solely do employment law, and we do employment law solely for employees. We never venture outside of that area. We never, under any circumstances, represent employers, and we don't represent any clients in any area other than employment law. It just happens that within this niche, we are by far as I know, the largest firm in the country that solely represents employees in employment matters.
Thank you, Wayne.
My pleasure. Glad to be here.
My guest has been Wayne Outten. He's founding and managing partner of Outten Golden in New York City. Thank you for watching.